Hi, folks. Hope you're doing amazing. My name's Dennis Vitoza, also known as Def Noodles, and we are back to share some of my thoughts on everything that's been happening. Today was a really big day because we finally got a Supreme Court ruling related to birthright citizenship. Now, if you all remember, I've made several videos covering this topic already, going back as far as last year. I also have a pretty interesting personal connection to this issue because my parents were here on work visas when I was born. In fact, my family still cannot permanently live in the United States because they don't have green cards. So they don't live here. They live abroad. That said, I am largely against the current form of birthright citizenship that we have. I support something much closer to the Singaporean model, where at least one parent must either be an American citizen or a lawful permanent resident. I know that under those conditions, I effectively would not have been an American citizen, but what's fair is fair. Just because I personally benefited from a system that I believe is dysfunctional doesn't mean I think that dysfunction should continue for the end of time. So, what exactly is the dysfunction that we are discussing today? I think there are really two major problems with the current birthright citizenship system. The first is birth tourism. Birthright citizenship has become an entry point into American citizenship through tourist visas. Depending on the estimates you look at, there are reports that somewhere between 50 to 100,000 people engage in birth tourism in the United States every year. Over time, that results in hundreds of thousands of American-born children whose parents return to their home countries shortly after giving birth. Years later, many of those children can come back to the United States for college or work without having to go through the immigration process that everyone else has to navigate. In some cases, they may later become part of a pathway toward family-based immigration. Even when that doesn't happen, they still receive an enormous advantage over people who go through the legal immigration system simply by virtue of having been born here while their parents were temporarily visiting. China has historically been one of the primary countries associated with this sort of practice, and it became so common that the Chinese government at one point publicly discouraged its own citizens from doing it because they were concerned about the number of people ultimately leaving China for opportunities in the United States. Now, the second loophole involves illegal immigration. Someone can cross the border illegally, give birth here, and then remain in the country without a clear timeline for departure by arguing that they need to stay as a primary caretaker of their American citizen child. In some situations, that child can later become part of a pathway toward legal status for the parents. Those are two very significant loopholes that we just discussed. Now, all that being said, at the center of this debate isn't just the question of what American citizenship should mean. There's also a human trafficking aspect to it because, in many situations, children are effectively being used as a means of obtaining access to the United States and, by extension, the resources and benefits the American taxpayers fund. We've seen examples of this in states like California, where I live. Last year alone, California spent more than $10 billion providing health care to illegal aliens, and that contributed to a serious budget pressure for the state. In fact, it put us at a deficit. That's money that could otherwise be reinvested into American citizens. Now, I know the standard argument from the left is that illegal aliens contribute more in taxes than they consume in public benefits, but I don't believe that's truly the full picture. Once you include the total cost of government services, including healthcare, food assistance where available, other welfare programs offered by certain states, public education, and increased demand on local government services like policing, you get a much broader understanding of the fiscal impact that illegal immigration has on the United States. Now, here's an example that fits neatly into all the categories I just described. California public schools are generally funded based on enrollment, not actual citizenship status. And as I mentioned earlier, there are also additional policing and public safety costs that come along with illegal immigration. Obviously, not every illegal alien commits crimes, but there is an undeniable criminal element associated with human smuggling operations, particularly those run by cartels, and those activities create additional burdens on law enforcement and our local communities. Now, with all of that background, let's talk about today's Supreme Court decision. The case arose after President Trump, at the beginning of his second term in 2025, issued Executive Order 14160. That executive order directed federal agencies to deny automatic birthright citizenship to children born in the United States whose parents were either in the country unlawfully or were present only on temporary visas. The administration argued that those children were not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. The order was immediately challenged by several states and civil rights organizations, and lower federal courts issued nationwide injunctions preventing the policy from taking effect while the litigation proceeded. The Supreme Court then agreed to hear the case, not to decide the ultimate constitutionality of birthright citizenship itself, but to address whether lower federal courts have the authority to issue nationwide injunctions blocking executive actions before a final decision on the merits. And in that instance, the Supreme Court ruled with the president, allowing the executive order to go back into effect. And now they are finally responding to the actual birthright citizenship aspect of the executive order. Now, with all of that context out of the way, let's take a look at this news package covering today's Supreme Court decision. Then on the other side, let's break down exactly what the court decided, what it didn't decide, and why this debate over the 14th Amendment is far from over.
It was an executive order that President Trump, on day one of his second term in January 2025, signed the executive order. It was immediately challenged, and now we can tell you that the U.S. Supreme Court has ruled against President Trump's order to limit birthright citizenship. Shannon, we have talked for some time about the president feeling that he would not win on this one. The question is, why not?
Okay. Right off the bat, it says children born in the United States to parents unlawfully or temporarily present are, quote, subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. So look how this broke down. As we expected, the Chief Justice wrote this opinion. Justices Sotomayor, Kagan, Barrett, and Jackson joined. Jackson has a concurring opinion in which Sotomayor joins. Justice Kavanaugh files an opinion concurring in the judgment and dissenting in part. The dissent comes from Justice Thomas. He is joined by Gorsuch, Alito, and then Justice Gorsuch apparently has his own dissenting opinion. So it is what we expected after the arguments here, and it looks like a bit of a split, but enough of a plurality coming together to say that the executive order that the president issued very quickly upon taking office is no good, and that if people are here, subject to the jurisdiction thereof includes people who are here illegally. Writing for the majority, Chief Justice Roberts says this: citizenship then and now was the right to have rights to freely participate in our political community. Talking about the 14th Amendment, the framers of the 14th Amendment extended that promise to every freeborn person in this land. That's a quote, and it looks like it's a quote back to some of the legislative debate about this in Congress. He says we keep that promise today. So a loss probably expected by the Trump White House, but it is official and it's a thick one.
Now, there are a lot of things that people immediately noticed about this case. The first is how the court split. The majority consisted of Chief Justice John Roberts, joined by Justices Amy Coney Barrett, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. Amy Coney Barrett's vote surprised some folks, although it probably wasn't much of a surprise to conservatives who had been paying attention to her judicial philosophy evolve over the last few years. Some people had assumed that because she adopted 2 children from Haiti, she might allow those personal experiences and feelings to influence how she approached immigration-related issues. So needless to say, Amy Coney Barrett joining the liberal majority caught a lot of people by surprise. That said, the person who generated the most discussion by far was Ketanji Brown Jackson, and not because of how she voted, but because of how she wrote. There are several different excerpts from her opinion that have been circulating online, and we're just going to look at a couple of the more eyebrow-raising ones. In one section, while discussing the aftermath of the Civil War and the adoption of the 14th Amendment, Ketanji Brown Jackson wrote that those who championed the 14th Amendment understood the assignment. I'm not joking. That's the actual phrase. Understood the assignment. That's modern internet slang that became popular on TikTok and social media, for those uninformed. We have a Supreme Court justice writing about one of the most consequential constitutional questions in the country while using terminology that most people associate with teenagers on TikTok. Needless to say, that's certainly one writing style. Good job, Biden. Quite a legacy you've left for our nation. And needless to say, it doesn't stop there. In another opinion issued the same day, this time in her dissent in the nationwide injunction case, Ketanji Brown Jackson took another approach that left a lot of people scratching their heads. Responding to the majority's argument, she wrote, "The power-hungry actors, ellipsis, wait for it, ellipsis, the district courts. Literally, she wrote, wait for it, in parentheses. Why are you writing like this? Are you seriously doing internet-style dramatic pauses in Supreme Court opinions now? Is this supposed to be more about making your opinion more relatable, more viral? Are we going to start seeing Gen Z memes, GIFs, worked into constitutional law next? It just comes across as unnecessarily unprofessional. These are decisions that shape the country for generations. At the very least, you would expect some level of formality. Instead, it reads like someone accidentally let their 12-year-old niece edit this section of the opinion. It's almost like the judicial version of "the dog ate my homework" somehow became "my 5-year-old niece got to my Supreme Court draft." What are we doing here? Anyway, that brings us to another moment that, to put it mildly, raised a lot of eyebrows while discussing whether children born in the United States are subject to the jurisdiction of the United States for purposes of the 14th Amendment, that is, the constitutional language at the heart of the birthright citizenship debate. Justice Jackson chose to use a metaphor to illustrate her point. Let's take a look at what she said.
I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a U.S. citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law. I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that.
So let me see if I get this straight. According to Ketanji Brown Jackson's logic, if I walk into somebody's home and take their PlayStation, not only do I own their PlayStation now, but I also own their home. Wow, thanks. That's amazing. Amazing application of the law, I see. Needless to say, there are so many questions that arise from this metaphor. Number one, why does your brain immediately go to you stealing somebody's wallet, huh? That's such a strange example to choose right out the gate. Says, if I go to Japan and rob somebody's wallet, please, come on, dude. Really? This is almost too on the nose. Are you doing this on purpose? Is this meant to be bait? You're telling me that the one female black justice on the bench is making a metaphor in favor of birthright citizenship, and the metaphor she chose is a criminal one? A stealing metaphor? A metaphor where she's committing a crime? Come on, dude. Really? And that being said, the logic itself just straight up falls apart. I mean, how do you even arrive at the conclusion that because you are physically present in a foreign country and commit a crime there, you somehow owe allegiance to that country? No, that's not how it works. Those are two completely different things. Sure, you can make the argument that you're subject to the jurisdiction of that country's laws while you're physically there, but it's very different from you saying you owe permanent allegiance to that country. In fact, when somebody commits a relatively minor crime in a foreign country, depending on the circumstances, a lot of countries don't even bother prosecuting them. They simply deport them because they don't want to bear the cost of keeping them in the country and putting them through their justice system unless it's a particularly serious offense. If it's something like pickpocketing or another relatively minor crime, many countries will simply deport you. In some instances, they don't even bother with that. They just simply wait until you leave the country and then ban you from ever coming back so they don't have to deal with a deportation process in the first place. That actually happens quite a bit. Sometimes you can even be barred from entering another country because of crimes you've committed elsewhere. And guess who does that? Canada. So her metaphor really implodes in and of itself, because being subject to local criminal laws while temporarily present is not the same thing as being politically subject to the jurisdiction contemplated by the 14th Amendment. And look, even if you try to make a distinction as far as permanent allegiance and any other sort of allegiance, I think that when you're talking about citizenship, we should only consider permanent allegiance not some vague, I'm under the jurisdiction of their law, thus I have some form of allegiance, and that should grant me all of the rights that are guaranteed to citizens under this law, because as we've seen, that can lead to all sorts of problems and abuses and corruption. And look, just overall, coming from Ketanji Brown Jackson, it's just some of the most profoundly unsmart, for lack of a better word. And I've got to use that misspoken version of that word because I need to come down to her level in terms of wits. It's just some of the most profoundly retarded reasoning I've heard on this issue. I honestly don't understand how this woman is on the Supreme Court. I have absolutely no faith in the Democrat Party when it comes to choosing somebody who's actually capable of holding this sort of job. It doesn't seem like she's improved at all or educated herself at all. More often than not, she appears to rule through her own biases, through her own philosophy, through her own wokeness, her own intersectional understanding of what America is, what America should be, and what the world is supposed to look like. And frankly, I don't think it could be more off base, irrational, or illogical than what she's presenting here. Now, look, all that said, here's my humble 2 cents on all of this. I'd rather have somebody who is extremely rational and logical on the bench than somebody who's simply a judicial historian who knows every precedent off the top of their head. Ideally, you'd want both, but here's the reality of the situation. She's neither. She's literally neither. She can't name the law off the top of her head. I've never seen her do it. And she certainly didn't do it here. She didn't mention a single legal precedent in any of the areas that anybody's quoting, not even in this argument that's going viral that she's making here. Needless to say, I'm sure that at some point, some of her paralegals included legal precedent and arguments in what she was presenting. Because if you actually go back to the 14th Amendment, the author of the Citizenship Clause, Senator Jacob Howard, literally explained during the debates what he believed the language meant. He stated, "Every person born within the limits of the United States and subject to the jurisdiction thereof is, by virtue of natural law and national law, a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons." That's the statement that's been making the rounds online, and I think it's an important one to consider if you actually care about historical precedent. Now, obviously, legislative intent isn't the only thing courts consider when interpreting constitutional language. Intentions can't necessarily be baked into the law forever, but if we're actually trying to understand the historical meaning of the Citizenship Clause instead of rewriting history to produce a broader interpretation that better serves modern political goals, then those debates absolutely matter. Otherwise, what you're doing is replacing the original understanding with a new one that better fits your current preferred policy outcome. And in my opinion, that's exactly what's happening here with these liberal justices. Now, taking this a step further, there are a lot of old tweets being dug up from when Amy Coney Barrett was nominated to the Supreme Court. One of the most widely shared is from Ben Shapiro. At the time, in 2020, he shared a Newsweek article titled "Amy Coney Barrett's Connection to People of Praise Explained," and wrote in a post, "This piece is why, on a political level, Trump should nominate Coney Barrett. The mind loss Democrats will assuredly manifest against the brilliant and charming Catholic mother of 7 will be good for Republicans." To me, that's the problem with team politics exemplified by a single post. When you start making decisions, important decisions, on what's good for the team instead of who's actually the most qualified person for a job that will influence the country for many years to come, you eventually end up disappointed. And Amy Coney Barrett fumbled the bag here. Now, I've also seen a lot of people trying to make this into a Catholic issue because several members of the majority are Catholic. And let me just say this. Clarence Thomas and Samuel Alito, who wrote some of the strongest dissents in this case, are also Catholic. So I don't think it benefits anybody to start blaming entire religious groups because of 1 or 2 justices' votes. Here's the reality. Amy Coney Barrett has more often than not voted against what many conservatives expected when she was nominated. That has largely been her profile from the very beginning. So honestly, I don't think this outcome should surprise anybody who's been paying attention. In my humble opinion, again, my 2 cents, her nomination wasn't a decision based on principle. It wasn't based on qualifications versus other possible nominees. I think she was chosen for this role of justice largely because of optics. And this is what happens when you prioritize optics over qualifications. Eventually, you end up with decisions that undermine the law and create consequences that can last for generations. Now, all that being said, one of the responses that's coming out of this Supreme Court decision are people on the right who support the decision that was made, calling for people to call for Congress to pass legislation or even pursue a constitutional amendment to narrow the current interpretation of the 14th Amendment. Now, do I think that's actually going to happen? Honestly, I don't want to be too black-pilled right now, but probably not. I don't think a future Democrat majority in Congress is going to support anything like that, but that's another conversation altogether. Now, something else that's been getting a lot of attention is Justice Clarence Thomas's dissent. As was mentioned in the Fox News package that we watched earlier, he issued a lengthy dissent, and one particular excerpt has been making the rounds on X. He wrote, "Until recently, this court continued to selectively enforce a colorblind constitution, including by allowing state-coerced racial discrimination in public education. Meanwhile, the court has repurposed the 14th Amendment to protect its own set of preferred rights that the Reconstruction Congress never contemplated and that cannot find support in its text. Today, the court does so again by recognizing a constitutional right to citizenship for the children of all foreign birth tourists and illegal aliens." He later continues, "I'm not sure that today's opinion will stand the test of time. The citizenship clause added greatly to the dignity and glory of American citizenship. Today's opinion devalues that citizenship. I respectfully dissent." Needless to say, I agree with Justice Thomas. I don't think this decision will stand the test of time. Now, there are different opinions about President Trump's executive order itself, and I'm not really going to spend too much time on those because at this point, it's somewhat besides the point. Some legal scholars think the executive order was drafted too broadly and that a narrower version might have received a different response from the court. Maybe, maybe not. Who knows? The reality is that it's been struck down in its current form, and I think this issue is inevitably going to come back before the courts in the future because here's the thing, folks. In my view, this entire dispute is fundamentally ideological. There's a reason all of the liberal judges lined up on the same side. I believe this alignment is driven by policy preferences, specifically a broader, more open interpretation of immigration policies. Neoliberal policies. From my perspective, this creates the possibility that if Democrats return to the White House in 2028, we could once again see a much more permissive approach to immigration and renewed pressure toward large-scale immigration. I think Democrats view long-term demographic change as politically beneficial to them. I think it's pretty obvious why, because it weakens the Republican coalition over time. Whether people agree with that assessment or not, that's just how political incentives have played over time and why Democrats are so committed to this sort of policy. Now, all that being said, I also don't think this interpretation is ultimately sustainable, even with mass neoliberal migration. The reason I agree with Justice Thomas that this won't stand the test of time is because I believe these broader immigration policies eventually run into practical limits. At some point, I think Americans are going to demand a more restrictive interpretation of the 14th Amendment, or perhaps Congress will eventually act to clarify what the subject to the jurisdiction thereof actually means. After all, there's a reason immigration was one of President Trump's strongest issues politically. Most Americans recognize that we have a serious immigration problem, and we've had it for many years. And here's another point that often gets overlooked. Whenever the media talks about immigration, the conversation almost always revolves around illegal immigration from Mexico or other countries in Latin America. But one of the biggest drivers of demographic change currently in the United States has actually been legal migration through programs like the H-1B visa. That program has resulted in a significant influx of workers, primarily from India, and we're already beginning to see the political effects of that in different parts of the country. Now, as I mentioned in another video this past week, one good example of this happened in Frisco, Texas. One of the largest cities in Texas saw its mayoral election significantly influenced after the local Hindu community, which historically wasn't a major political force in that area, organized behind a particular candidate. That's the sort of political realignment we're going to continue seeing happen over time. We're also seeing statues of Hindu deities being erected in different parts of the country. The face of America is changing because of these sorts of decisions. And my broader point is that if there isn't some meaningful mechanism for controlling immigration, then the demographic, cultural, and political character of our nation will continue changing permanently. The United States was built around European Christian values and a predominantly European identity. And if these neoliberal immigration policies continue indefinitely with no checks, I don't think much of that character will remain. And as we all know, it's a lot easier to let millions of people into a country than it is to track them down years later and remove them. That's exponentially more difficult and far more expensive to accomplish. Anyway, folks, we have to pray for our country in moments like this because I think things are about to get a whole lot crazier over the next few years. So you tell me what you think in the comments down below. Hope you have a terrific day. Peace.